Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota, and we are recapping day 21 of the Karen Read trial, and I'm going to, at the end, show you what I think is the most important thing that happened today, which was not hard to find. Not hard at all. Most of the day, it felt like, was spent in the cold, abysmal hell of loneliness and silence and sidebar and breaks. It was ridiculous. There must have been quite a bit of argument going on, and it all seems to center around this doctor. What was his name? This is terrible. I shouldn't be doing this right now. Let me look it up. Wait for a second to go ahead and figure out who that was. Dr. Judson Welchure was his name, and he is a PhD in biomedical engineering. And he also is a crash reconstructionist. And that was his purpose today. His purpose was to come and explain how the impact to John O'Keefe occurred. So we have had medical examiners and testimony to a high degree of medical certainty or scientific certainty how the injuries caused John O'Keefe's death or how something has happened. But what we have not had was an expert come in and testify how the car struck John O'Keefe and how it then produced physical, tangible results that we see on his body. They talked about the wounds on his arm. They showed, or they talked about the hematoma, whatever it is, above his eye, the hit to the back of the head, all of these things. And the crash reconstructionist, Dr. Welchure, his job was to explain how those things literally mechanically happen. So I said mechanical certainty, but it's an engineering certainty. So it's just a different field of application, right? You have a medical application, you have a scientific application. This is an engineering application because it involves mechanics and reconstructing those mechanics and explaining, again, mechanically how these things occurred, not what they do to the body after they've occurred. That's a different thing. This doctor seems well qualified, and his degree in biomedical engineering allows him to have some medically related opinions, even though he's not technically a doctor. He had some parallel training that he went through on his direct examination, explaining his CV. I say on his direct examination, it's still on direct examination. It was the longest direct examination I could have imagined because it just kept going and it was so boring. And there were a lot of long breaks in it. But that being said, the state did elicit testimony that due to a reasonable degree of engineering certainty that Karen Read in her Lexus SUV struck John O'Keefe on the night that he died, that happened. So that testimony is in evidence to some degree, I believe, but it gets a little bit confusing because of what happens at the end of the day. Direct examination is still going on, but the judge dismissed the jury at a good break in the testimony. And what we were treated to afterwards is what I would consider the highlight of the day. And we're going to watch it. It's about 10 minutes long, a little bit shorter. And it is Alessi and Hank Brennan arguing over a line of questioning involving this witness. The defense does not want a witness who is saying to any degree or who is asked the question, did Karen Read hit John O'Keefe? Because this is the core question of the murder, of one of the elements of the murder, and that is not the job of the expert here. Now, the question that you can ask is, can you, to a reasonable degree of engineering certainty, assert that the Lexus SUV owned by Karen Read struck John O'Keefe on the night of January 29th, blah, 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 at approximately 12:29 a.m., whatever it is. I don't remember the exact time. You get the idea. They can ask that question, and that is what this argument is about, the ability to go down these line of questioning, or this line of questions for the state. Alessi does not believe that the state should be able to ask questions in this way because it asks an expert to comment on a core element of one of the crimes. Hank Brennan actually has a really good argument back, and so we're gonna watch this exchange. I think it is the kind of the most important thing that happens today. It doesn't happen in front of the jury, but it will kind of set the tone when Bev Canoni rules on it, which presumably will be tomorrow morning. Dr. Welcher will be back. He was originally only going to be here today, but they didn't get anywhere close to finishing up his testimony. So, in the meanwhile, why don't we go ahead and do this guy? And then let's watch Alessi make his argument and then Hank Brennan make his argument, and I'll try and comment about what's going on as possible.
Your Honor. The point number one is the question of whether, based upon a reasonable degree of scientific or engineering certainty, he has an opinion whether a collision occurred. I'm going to give a dramatic and accurate example that happens in courts all the time we put it. So, by analogy, if the issue is whether or not a defendant has stabbed an individual and caused a certain event, that is the ultimate question for the jury. That question is never permissible in a trial.
Okay, so Alessi is asserting that in a hypothetical other trial, the question of some sort of murder involving the stabbing, the defendant stabbing someone. There is his assertion is that it is never allowed to ask that ultimate question. Did the defendant, according to the expert, do the thing? Did they stab? Did they do it? Not could it have happened? Not does it align with the possibility of it happen? Not could this knife, is this knife to a reasonable degree of medical, biomechanical engineering, metallurgy, whatever, certainty? Is this knife consistent with injuries that are found on the decedent? Those types of questions are okay. You cannot ask to a reasonable degree of engineering certainty if the defendant did the bad thing. So that's what Alessi is arguing here, that by asking if the Lexus, which has been described as the murder weapon by the state, if the Lexus itself, if he can ask if that car, struck John O'Keefe, because that then implies that Karen Reed is responsible for that. And that I don't think is actually that solid of an argument. And I think Hank Brennan's comeback to it is pretty good, but let's get there.
By analogy, this is the exact analogous situation. The question of whether there was a collision is the ultimate question for the jury.
I disagree.
That is why we are having this trial. The defense strongly asserts.
I like Alessi, but the idea that a collision occurs is not, did Karen Reed do it? Now, I know it's not part of the defense's theory, but for example, even if it's Karen's SUV, it could be driven by someone else. And that collision could be, the defense could be like, well, she didn't do it. Like, she wasn't the driver of the car. She wasn't in the car. She was traipsing around drunk in a robe. Like they could have other things. They just don't. They don't have another thing. They have their theory of the case. They know that. Everybody knows that. But when you get down to what is allowed versus what is not allowed, what is not allowed is the asking of the ultimate question. But the question is always, is this the ultimate question? Was John O'Keefe struck by this Lexus? Is not, did Karen Reed murder John O'Keefe with a Lexus? Those are two different things.
There was no collision, and there is substantial evidence to that. We are going to cross-examine Dr. Welcher.
Great.
We're going to put in our own strong case to demonstrate no.
This does not
occur. That's no surprise. It was in our opening statement.
Doesn't have anything to do
This
with the state's questioning.
Cannot, precedent for years opine on the ultimate question that is going to the jury.
So far, he hasn't.
Subject to evidentiary issues, the two questions that a biomechanist always answers in these situations. Is the damage to the vehicle consistent with a pedestrian hitting the vehicle? And are the injuries to the individual consistent with being hit by a motor vehicle? Those are the questions that are permissible, not the collision question. It is resoundingly improper in this trial, in any trial.
He's trying here, but I disagree with him. I get what he's saying. He's saying like, okay, so damage to the car, damage to the body. Do these things, do they match up? But this is a crash reconstructionist, biomechanical engineer, sure. But I think I don't see why he wouldn't be able to ask or to ascertain whether, again, he can determine if a collision occurred or not based on what he's seen and what he presents. And I think they'll rip him up on cross, but I don't see the impropriety of the question myself.
That is the ultimate conclusion for the jury. Yes, an expert can offer opinions, but every expert is bounded by the extent of their opinion, and that opinion on whether there was a collision would invade the province of the jury and the whole purpose why we are here, Your Honor. Thank you.
All right, Mr. Brennan.
So again, his premise is that even asking at all for this guy to say that any collision occurred goes beyond the pale that goes to the core issue. But that's not true, because a collision could have occurred from someone else. And he could have said that or his answer could be that no, the injuries with John O'Keefe's body are not consistent with the Lexus. They would be consistent with a different type of vehicle, which has, maybe surfaces at different spots or different heights or whatever. That could, in theory, be an answer. And it's just that it's not an answer. But the fact that it's not the answer doesn't mean that there isn't the possibility of another answer to the question. And so, again, I don't think this goes to the core issue. Asking if he could determine that Karen Reed drove a car into John O'Keefe and that she tried to do it, even more specifically, that would be core questions that he cannot answer. And I think that would be very improper.
So what Mr. Alessi is arguing is that in their opening statement, they repeatedly invaded the province of the jury because they must have asserted vehemently over and over again there was no collision, over and over and over again. And he just told you that when his expert takes a stand, they'll have abundant evidence that there was no collision. This case is about the collision, but that is not the ultimate issue. The ultimate issue is manslaughter or mens rea for second-degree murder, not collision. They don't get to define the prosecution's case. They do not get to define or limit the prosecution's opinions. They have no case law. They have no study. They have no jurisdiction or jurisprudence to say what we are limited to.
This is the best Hank Brennan has sounded that I've heard all trial. Like, this is a solid, concise argument, and I largely agree with it.
Entitled to an opinion. His opinion is not limited to whether or not the defendant struck Mr. O'Keefe. That evidence is obvious. It's not whether or not there's damage to the car or Lexus. That evidence is obvious. He also is an enormous part of a biomedical engineer and an accident reconstructionist. He studied the tech stream data. They didn't, he did. And he's entitled to give an opinion. The tech stream data, based on fact and science and data, tells us when, if you put it together with other evidence.
Now, let me just say that the tech stream data is complete bullshit, and it contains this notion that we saw coming from Shannon Burgess that you can completely just rewrite the timeline of what happens within the Lexus by 21 to 29 seconds at your whimsy. And within those 21 to 29 seconds, the state is able to reconstruct and move certain events that are logged by the car and change reality, change the history of what happened. And their reasoning and ability to do it is, we interpret that the time was wrong to this amount, so we will adjust it by this amount. And that's insane. That is an absolutely dumb standard or dumb application of what they've done. And it doesn't make any sense. But, that is the testimony that they're looking to elicit and to utilize. And so therefore it will be up to the defense to really just hammer him hard on cross, especially knowing the lack of qualifications of Burgess. What did Dr. Welcher know about his qualifications? What did Dr. Welcher know about the papers that were written that got basic mathematic details wrong? Things like that. Was he aware of these things? If he was, how could he possibly base his findings on such shoddy work? Did he do any of the work on his own to check it? What steps did he take to verify that he, who seems to be an actual expert in biomechanical engineering, is utilizing the right set of data versus versus a different set of data? And then further, if he did, what qualifications does he have to actually check this out? These are good questions that we'll see on cross that I'm looking forward to.
And where, when you contribute it with other evidence, this collision actually occurred. We don't have to play peekaboo and close our eyes to the reality of the fact that the evidence supports the conclusion to a reasonable degree of engineering certainty that the defendant struck Mr. O'Keefe with her Lexus in front of Fairview Road. I am not interjecting the defendant. I always refer to her car, so it is sanitized, her Lexus. I've been careful about that. I don't have to, but I'm very careful.
I don't have to do that. I don't have to do that.
He is relying on the test stream data, the physical evidence, his independent studies. He is allowed to offer an opinion about whether the injuries are consistent with the damage to the car, whether the damage to the car is consistent with the injury to Mr. O'Keefe. And he's also allowed to answer, in his opinion, the issue of a collision, putting aside the fact that that was emphasized and repeated in the opening statement, and it's going to happen again when other people testify. It's not our fault that ARCA didn't testify or look into the tech stream data, or they don't have an expert for it. It doesn't.
Wait, it actually kind of is. It actually kind of is your fault, Hank. You've been fighting against ARCA's ability to do this the entire time. It's insane. Or it's not our fault. It's not our fault. You're literally getting parts of their testimony restricted from the record. So let's not be too hasty there. I liked your argument up until now. Don't lie. Don't be a dick.
Little or limit that evidence. We expect to ask Dr. Welcher, does he have an opinion to a reasonable degree of engineering certainty whether the defendant's Lexus collided with Mr. O'Keefe on January 29, 2022, around 12:32 a.m. That is one of the opinions we're going to ask him. Nothing to do with the ultimate opinion of guilt or innocence, or whether it's manslaughter or there's mens rea for second-degree murder.
And what was your second? You said that's one of the opinions you're going to ask him. What else are you
I
looking
will
at?
also ask him about the consistent with, whether the injuries are consistent with.
With what?
I'm going to ask him after this part about the difference between
This
a
girl's
flip or a
brave.
side swipe as opposed to a full-on injury, pedestrian collision from a front or back of a bumper. And there are further slides to emphasize that point. And so there'll be an opinion regarding that as well.
And you,
Consistency with a side swipe or a clip.
okay, so this is not the end of Dr. Welcher's testimony. He's just moving on to another area.
It's close, but it's not the end.
Okay. Go ahead. Yeah.
Your Honor, here's a case. Attorney Brennan said, go to case law, here it is. Commonwealth v. Coleman, 366 Mass 705. And it stands as a proposition exactly that I articulated. I won't repeat it. Secondly, Your Honor, we practice what we preach. I have the ARCA report right in front of me, and I have the report of.
Is that a new one or is that a?
This is the new one.
Okay.
It's also, the old one is the same. So I can, either one is the same. They do not, Mr. Brennan incorrectly said what our experts are going to do. I don't know why he did that, because he has these in writing. Neither Dr. Wolf or Dr. Welcher talk about a collision or conclusion. It's consistency. It's those two questions I said at sidebar. And for reference, Your Honor, for the most recent is page 15. There is no.
I don't have that report, so I'd like a copy of that report.
Your Honor, a copy, and I also, Your Honor, refer Your Honor to ARCA's existing report, which I'm going to do from memory, I think is February of 2024, that was done for the U.S. Department of Justice and FBI, where they basically said and gave opinions on those two items I spoke to you at sidebar. So Attorney Brennan is incorrect when he says what our experts are going to say or not. We've already committed in writing to what they're going to say. We're consistent. We practice what we preach.
All right, so we will discuss this tomorrow.
So Alessi there is hitting on this practicing what they preach. And what he is saying is, look, we've got the report, but we are sticking with the report. We're not changing things up. We're not pulling any curveballs. We're not doing anything like that. We are actually sticking with what we said we were going to do in this trial. The question is not, it's not that sometimes you surprise the other side, but the objective of trial is not to surprise the other side. The objective of trial is to elicit sufficient facts. And typically the other side is kind of aware, at least of generally where you're going. And on some issues, they may have to be specifically aware of where you're going to go. And in this case, of course, they have expert reports going back and forth and a conflicting timeline. All of this stuff is going to be hashed out in court, and it has to be done the right way. And the judge has expressed that she doesn't want things really changing at the last minute here. So the question will be just, can we get these out of the experts, and how credible are the experts to the jury, not hide the ball from the other side. So that's what we've got here. And I just thought this closing sort of this back and forth argument was really important. Mainly one, because it's the first time I've really liked Hank Brennan's argument. And I think that he has the better argument here. I mean, certainly the judge could rule in favor of Alessi. She's not gonna. It's not gonna happen, but she could. She could do that. And Alessi's point is like this: they're getting to the ultimate question. You're not. The reason this is important is you can't have an expert who has bolstered credibility by all of these credentials and by all of their experience come out and say, yes, she drove the knife into his chest. If you do that, the credibility of the expert, who's supposed to be neutral also, even though they never are, the credibility of the expert is lent to the opinion on the ultimate question. And that is very, very influential to the jury. And in the case of being favorable to the state, would be highly prejudicial to the defense. And if the defense were trying to do this, the state would be just as pissed off and would not want them to do it too. So Alessi has some level of a point on the fact that an ultimate question has no place going to an expert before a jury. Of course, it's just the question is whether or not this is an ultimate question. And I don't believe it is. And sounds like Hank Brennan doesn't believe it is. And I think Judge Cannoni is going to rule against Alessi, and they're going to rule in favor of the state, and not because of bias, but because I think it's the right thing to do. So I wanted to highlight that clip and that argument, because even though I really like Alessi, personally, I still believe that Karen Reed should be winning this case. And I don't think the state has done its job. I think that this was an excellent highlight of Hank Brennan being a good lawyer instead of being a giant pile of trash. And so you want to do that when possible. And he makes a good argument. So with that, we'll see you for day 22. I hope you guys enjoyed the show. And I hope you enjoy these recaps. Look, I know I get a lot of positive feedback in the comments on the recaps. Please share them out. Let people know that we're here. If you're still watching, I'm too dumb to say this up front. I am live streaming this trial every weekday that it's on, 8 a.m. Central Time. And we go till court is done. And then, we wrap up with any questions or commentary. Sometimes we have a guest or an interview in the middle of things. Sometimes I just mess around with Grok and see what's out there. We watch testimony from the old trial when there's nothing going on. Sometimes come make it your own. Tell me what to do. Conspire with your fellow viewers, and we'll enjoy this thing together. We'll laugh at a bunch of stuff. But most importantly, we'll see the fate of this woman, Karen Reed, who's put on display before the entire world. With that, I'll see you soon. Have a good day. Peace. Peace. You don't just Just end the show.